Hi, everyone. My name is Sydney Tenton, and today I am going to talk about competence to testify, a legal concept that determines whether a person is legally allowed to provide testimony in court. This is actually a critical piece to what happens in courtrooms. This isn't just about being present in a courtroom, it's about being mentally and cognitively capable of giving meaningful and trustworthy information that a judge or jury can rely on. This presentation is based on psychological evaluations for the courts by Melton and colleagues, fourth edition. Let's start by exploring why this topic matters. Witness testimony can be one of the most powerful elements in a legal case, especially when there's limited or conflicting physical evidence. However, not everyone is automatically allowed to testify just because they were present during an event. Competency becomes especially important when the witness is a child or someone with cognitive or mental impairment. Courts must determine whether the person can provide accurate, reliable, and truthful information. This ensures fairness is the legal process while also protecting vulnerable individuals. Legally, competence to testify means a person is capable of giving meaningful and reliable testimony in court. According to Melton and colleagues, there are four components to the standard. Number one, the individual must be able to perceive the events accurately. Number two, they must be able to recall those events with reasonable consistency. Number three, they need to be able to communicate their observations either verbally or non-verbally. And lastly, they must understand the obligation to tell the truth in court. If any of these abilities are in question, a court may require a formal evaluation and hold a hearing to determine competency. When competence is questioned, a forensic psychologist or psychiatrist is typically asked to conduct an evaluation. These professionals assess a wide range of areas. Cognitive functioning. Can the individual think clearly, remember details, and reason logically? Communication skills. Are they able to express themselves clearly and understand questions? Understanding of truth and lies. Do they recognize the importance of honesty in a legal setting? Suggestibility. Are they likely to be influenced or led by others, especially by leading questions? Lastly, psychological or psychiatric symptoms. Could conditions like delusions, hallucinations, or severe anxiety impair their testimony? The evaluator's job is to provide an expert opinion, but not a final judgment. Children are a common group for whom competence to testify is evaluated. Courts want to include their voices, especially in cases like abuse, neglect, or custody disputes. Even though children might not fully grasp the courtroom procedures or legal terms, they can still be found competent. The courtroom is mainly concerned with whether they can distinguish truth from lies, provide coherent answers, and stay focused on the event in question. Developmental psychology research often informs these decisions, and the court will take a child's age, maturity, and communication skills into account. For individuals with cognitive or psychiatric disabilities, the legal system generally presumes competence unless there's clear evidence to the contrary. This means a person with an intellectual disability or mental illness still has the right to testify unless their condition clearly prevents it. However, concerns arise when symptoms like delusions and communication difficulties make their statements unreliable. Courts have to carefully balance inclusion and fairness, avoiding discrimination while also ensuring the integrity of the trial. This is where evaluations become especially important in determining whether accommodations or alternative methods of testimony are needed. It's important to understand that psychologists and psychiatrists do not make the final decision about whether someone is competent to testify. That responsibility lies with the judge. Mental health professionals often expert opinions. Mental health professionals offer expert opinions through reports and testimony, but the judge evaluates all the evidence and determines competency, typically during the pretrial hearing if the issue is raised. This ensures that the decision is grounded in both legal and psychological reasoning, with the ultimate goal of protecting the integrity of court processes. The video I've included is called Witness Competence and Criminal Evidence. It provides a clear, accessible explanation of the court components of testimonial competency, especially in children. It walks through how a child's ability to perceive events, remember them, communicate clearly, and understand the importance of truthfulness are evaluated. What I liked about this video is that it shows practical examples and courtroom interactions that match the legal and psychological criteria described in our textbook. It helps bridge the gap between academic theory and real life application. I would like to now turn it over to you with a question. What are the potential risks, both legal and ethical, of excluding someone from testifying because of concerns about their competence? On one side, excluding a person may protect the legal process from unreliable or confusing testimony. But on the other hand, we could be silencing someone whose perspective is vital to the truth. This is especially relevant for marginalized populations. How do we balance the need for reliable testimony with the need for inclusive justice? To wrap up, competence to testify is a legal determination supported by psychological evaluation. Most people are presumed competent unless there's a significant concern. Psychologists assess competence, but judges make the final call. Special care is given when the witness is a child or has cognitive or psychiatric disabilities. The court must always balance fairness, protection, and truth-seeking when deciding who can testify. Thank you for tuning into this information regarding competence to testify.